Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
This is Serious Privacy by TrustArc. Here are your hosts, Paul Breitbart and Kay Royal.
On October 7th, the United States government published a long-awaited executive order from President Biden that will regulate the protection of personal data when used for government surveillance purposes. The order was created at the request of and following negotiations with the European Commission in order to address the concerns raised by the Court of Justice of the European Union in the so-called Schrems II judgment. And it is intended to provide additional safeguards, on the one hand, to the collection and use of personal data by the US intelligence community, and to create additional redress mechanisms on the other hand. And even though the executive order largely has immediate effect, some steps are still required on both sides of the Atlantic before it can really be a replacement for the now defunct Privacy Shield. And is it really an EU-US agreement? Lots of questions to discuss today. My name is Paul Breitbart.
And I'm Kay Royal, and welcome to Serious Privacy. So the secret question, this time I was going to say, do you have a secret? But no, let's go with, what is your heroic downfall, your Achilles heel?
Imposter syndrome.
Oh, yeah. They talk about that for women professionally in large part, but it's not just women.
No, it's not just women.
I'm beginning to think that it really relates to those who are very passionate about their jobs, who are very driven to make sure they do so successfully, because those are the ones that seem to be worried that they're not doing enough, that they're not good enough for what they're doing. They take it seriously. The people who show up as often office drones, 9 to 5, don't give a crap, you're never really sure what they're doing, they don't ever seem to care.
No, and I think it also depends on how much you know about your field of work, because the more you know, also the more you realize you don't know.
I was going to say, wait a minute, Paul, I know a lot about my field of work, and I'm pretty sure I don't know it all.
Well, that's the thing. If you are overconfident and you think, I know it all, but when you get really into a topic, then you start to realize, no, I actually do not know it all, and I'm not certain about my views and my analysis, as we will probably also discuss today in this episode.
Yes. So we are releasing this one fast and furious, which means y'all are going to get the editing y'all normally do, but you'll get some minor editing anyway. My Achilles heel is, well, I was just looking at my book, and what I've written in the past is exactly what came to mind today. My kids and animals being hurt. Now I'd have to add the grandkids into that.
Fair enough.
Yeah. And so, yeah, you'd think I'd be a vegetarian, but no, sorry.
You're also still Southern, right? I mean.
Exactly. But I will tell you, the dairy farms here in Arizona just make me cringe. I don't ever want to drink milk anymore. But okay, we're going to talk about the executive order that came out. It was just issued on October the 7th. There were some other things that came out pretty much simultaneously, like the Department of Defense is going to issue some regulations.
Department of Justice has issued some guidelines on the so-called court.
Yeah, exactly. So there are other things that have piled on with it. And I've heard some pretty good analysis of this and conversations of this, but I thought that, maybe our listeners would enjoy our take on this, given the two sides of the pond that we're on. So as part of this, I went through and read some history on executive orders and what are executive orders and how legally enforceable they are and when are they not enforceable. And I'll say the first thing, and we could give a quick summary. I know you did in the introduction, but we could give a quick summary as well. This is part of the EU-US data transfer mechanism, since the SHIELD was invalidated in 20, following the safe harbor being invalidated in 16. This is like the third strike. This is the US, you got to come up with something. And they had announced a principle in agreement, or hold on, reverse that, an agreement in principle. Although the other is weirdly accurate. A principle, I'm going to go there again, an agreement in principle that they will resolve this, that there will be a fine. And so with that, we've been waiting what's going to happen. So President Biden eventually issued the executive order on October 7th, which has a few elements in it as to what it's going to do. And the two things that they're trying to get across is the fact that foreign individuals, not just U.S. individuals, need to have a right of redress when it comes to their individual rights, and they need to be enforced on that. So that's the main part of it. And we've already heard from, people like Max Schrems that he doesn't think that the executive order is enough. A lot of people are saying executive orders aren't enough. They don't have the full force of law. Congress can overturn them. Okay, I'm sorry. Congress can overturn any law that Congress has passed. If that's going to be your logic for an executive order isn't good enough, well, then no law is good enough because Congress can overturn it.
Yeah.
If Congress doesn't overturn it, the courts can say it's invalid. That's the same thing with an executive order.
Hey, that's happened before on this issue, right? That the courts have said it's not good enough.
Yes. But it's the same thing with any law. So here's the thing. Executive order has the force of law. Until Congress can't just say, go away with the executive order. They have to pass a law to overturn it if that's the way it's going to be, if the executive order doesn't have a natural deadline enforced in it or something like that. But there have been some pretty historic executive orders. One of them was the one that really stands out to me. It was President Lincoln's proclamation against slavery was an executive order. Now, executive orders can only be issued if under where the president has the authority to do so. Mm-hmm. So Lincoln, being the intelligent man he was afraid that his executive order would be overturned once the war was over because it was issued under his authority in wartime. It was not. Came up with the 13th Amendment then. So there are some significant executive orders out there that have withstood the test of time. I mean, I think one of them was an executive order established Thanksgiving here in the U.S. I mean, that's a minor example, but it's an executive order. So let's see. Lincoln also suspended the writ of habeas corpus during Civil War. That was one that stood. Now, of course, the Federal Circuit Court Justice Roger Taney. Oh, no, he was Supreme Court at the time, but in his role as a Federal Circuit judge, he ruled that it was unconstitutional, but everyone ignored him. Lincoln ignored him. The Union Army ignored him. Congress didn't contest it. There was nothing. So just to let you know that executive orders are pretty powerful and they carry the force of law. So, and they do apply to federal people. So this executive order, given the fact that it is addressing the signals intelligence, which, yes, I had to go look up what the heck is signals intelligence. But given that it applies to the signals intelligence community, which are all federal, then it has the force of law. I don't know why people keep saying this isn't good enough.
Well, I can come up with a number of reasons why it is maybe not good enough, but not that it hasn't got the force of law. I think one of the things I've learned in all these discussions on Privacy Shield and Safe Harbor and now this replacement in past 8 years is that the U.S. legal system is quite different from the one we have in Europe. And also your court systems are quite different. And there are many things that I maybe disagree with. Even your constitution is different because it only applies to U.S. persons. And that still amazes me. But I mean, that's not the discussion that we'll have today. I think, to be honest, I think the whole process is a bit meh. And yes, it's nice that the executive order is out now. And then an hour later, we got an update to Executive Order 12333 and then, or to the Presidential Policy Directive 28. And then another day later, we got the Department of Justice guidelines, and there's still some other documents that allegedly are coming. And then there are some that will need to be drafted in the next 60 days. So somewhere between now and Christmas. the UK is suddenly claiming that they have success in these negotiations while they didn't even have a seat at the table. And
exactly.
then there is, I mean, the whole package still needs to be assessed as part of an adequacy decision, which
It does, which is going to take a while.
it will take a while, but that adequacy decision is mainly also aimed at the commercial side. And there is no word yet from Department of Commerce on the Privacy Shield principles. What happens to those? Have those been revised and updated in line with GDPR? Because the previous principles predate GDPR. They go back to the directive. So that is something, I mean, the whole process is very messy. And that makes it hard to predict whether or not this will lead to an adequacy decision. But if you peel down on the executive order itself, I'm not as negative as the initial response from, for example, Max Schrems is.
Right. I was just looking up an update on the U.S. Secretary of Commerce put out a statement as well. It was also on October 7th that, did she talk about updating the Shield?
I don't believe she did.
I think, here we go. The EU-US, they're calling it the DPF, Data Privacy Framework, will also update the privacy principles that companies adhere to under the EU-US Privacy Shield Framework and will rename them as the EU-US Data Privacy Framework Principles. They will restore an accessible and affordable data transfer mechanism for U.S. companies. They will work with the current Privacy Shield participants, 70% of which are small and medium enterprises, to facilitate the transition to the updated privacy principles under the DPF. And following the issuance of the executive order, U.S. Secretary of Commerce Gina Raimondo says that she will transmit them to the European Commissioner, a series of letters from relevant U.S. government agencies and documents outlining the operation and enforcement of the DPF.
Okay.
So that's good. I had missed that had come out in the midst of everything else.
Yeah, I think that statement was later updated because I think the initial statement that I saw was just, we welcome the executive order and nothing on those principles. But that's, at least it's a good indication. But again, it shows what a messy process it is, because they should all have been released as one package at the same time.
Yeah, there should have been one package that came out, exactly.
With just PDF documents that you can actually annotate instead of just a web page where the full text in a very weird numbering was posted.
Sorry, format over form.
Well, I mean, content is important, but to understand the content, especially for complex things like executive orders, it helps if there is logic to the hierarchy in the document.
Hey, don't expect too much here. There is no logic at play here.
Weren't you the greatest country in the world, according to your own claim?
Yeah, we're not going to go there. So
okay.
I gotta go there.
So let's go into content a little bit more.
Yeah, just a little bit. Let me pull up my stuff here so we could talk detail and everything else.
And yes, I'm still writing my analysis, but knowing myself, this will look more like a first draft of a EDPB opinion with all the cross-referencing that I want to do than just a short blog with a sweet and short conclusion. So bear with me.
Yes, my goal is to get mine out this week before I go on vacation in 2 days. Okay.
Yeah, right.
Yeah, I'm stupidly excited about going on vacation. I'm going on a 12-day cruise out of New York to Galveston, stopping at what they call the ABC Islands, Aruba, Bonaire, and Curacao.
So you're coming to the Netherlands.
And Cozumel, right?
You're coming to the Kingdom of the Netherlands because the ABC Islands are the Kingdom of the Netherlands.
But yes, I did notice that.
So yeah, you'll be in my country.
I'll be in your country. I'll be in the territories of your country. I appreciate that.
No, you'll actually be in my country because Bonaire is too small to be an independent country. So that is actually part of the Netherlands.
Nice. I actually looked that up for something. Oh, yes. When I was doing a quick study a few months ago about the number of countries in the world, because there's a variety of lists for how many countries there are in the world. And that just irritated me. I'm like, a number is a number. You can't just, so I was looking up as to why. And some of them are because of the territories. Some of them are because they're considered independent governments underneath them, like Hong Kong, different things like this. So depending on how they count them there is whether or not they call them different countries or not. So that was interesting.
Okay.
My count was different than the way TrustArt counts it because I felt that I think it was the Encyclopedia Britannica's count made a lot more sense, but I still tweaked it to include Hong Kong and things like that. Anyway, so yes.
Okay.
I get caught on these really detailed things because it irritates me when some people say there's 181 countries and other people say there's 192 and others go there's 150. Yeah. So
that's what they call the rabbit hole of the internet.
Is what they call the rabbit hole of my brain. Sometimes I'm beginning to think these little details. I like to be precise where preciseness counts. For some reason, the number of countries in the world seems to require a precision that is lacking. Okay, so yes, let's talk about the executive order.
So speaking about precise, how precise do you think that the legislation actually is when it comes to necessity and proportionality of signals intelligence?
Yeah, that's going to be the interesting thing because that is a judgment. So the necessity of proportionality it's always in someone's opinion. And then typically it raises up enough to where a court or a legal authority tells you where the opinion is. So our necessity of proportionality is probably quite different from Europeans' opinion on what the necessity of proportionality is. But what I do find encouraging is that they're all going to funnel up through one authority who will start giving us what that proportionality is officially. And that part I'm really excited about. So I do think that the Civil Liberties Protection Officer, who's going to sit in the National Intelligence, I do think that the Civil Liberties Protection Officer is a great step. I do like the Data Protection Review Court because those will be independent. They are not going to be the same judges that are housed now inside, the agencies.
The FISA court or...
Exactly. They're going to be different. And then you're going to have we have the Privacy and Civil Liberties Oversight Board already, but they're going to go through and start reviewing the policies and procedures. And we've already seen some talk about policies and procedures changing for that. So I do have some hope that probably sooner rather than later, we're going to start seeing some official statements on what this necessity is or how far does the necessity go when it comes to proportionality. So I am hopeful, but as our listeners know, I am eternally hopeful when it comes to things like this because I have faith that the U.S. is going to step up and do what it's supposed to do, dadgummit.
Well,
I volunteer myself to be one of the judges. Let's just put it that way. Okay, that's funnier than it should have been.
Very good. I think in general, the necessity, I do not have too many concerns, also because there is quite a clear list of objectives for which the data can be collected. And that list, to me at least, makes sense. And I don't think that you'll find any other European surveillance law that is more specific or vastly more specific than the objectives listed in the executive order.
Now, do you find it interesting that we're expecting the EU countries to tell us if they offer equal rights to U.S. citizens?
Yeah, let's get to that in a moment. Let's peel it down a little bit in structure. Because on the proportionality, I still have concerns. And indeed, one of them is, as you say, the understanding of what is proportionate in the US and the European Union can very well be different. There is, of course, still allowance for bulk collection of data, whereas both the Court of Human Rights and the Court of Justice of the European Union have time and again said bulk collection only in very, very limited circumstances could it be allowed for a short duration of time or for a very specific location in case of an immediate threat. And you cannot just do bulk collection whenever you please just for the sake of it. And I'm not sure whether those conditions of the courts are met in this executive order. Time will tell. It is to some extent comforting that there is an ex-ante review of every surveillance operation because they need approval or at least an assessment from the Civil Liberties Officer, the Civil Liberties Protection Officer. So that is, I think that's a step in the right direction, but of course that can still be overruled by the director of the agency and then would only come up once the Privacy and Civil Liberties Oversight Board would do an investigation and might come to a different conclusion.
Right.
So that is a concern. I also still don't know what a qualifying complaint could be. So when is a European or anyone that is qualified under this executive order, when are they able to file a complaint and say, hey, listen, I don't believe that my personal data were treated right and that you had the right to collect them in the first place? If you have that suspicion, I have not seen any documentation on that. Maybe that's still forthcoming.
It's coming. It's addressed in Section 3, Signals Intelligence Redress Mechanism. So it talks about within 60 days of the order, the director, in consultation with the Attorney General and the heads of the intelligence community that handle these personal information, shall establish a process for submitting qualifying complaints, and then the initial investigation of the qualifying complaints by the privacy officer. And so that entire section deals with how they're going to establish what those complaint processes look like. Now, it doesn't tell you what the complaints process looks like, but it tells you that they're going to come up with it. So expect another update in about 60 days.
Yeah, so that's sometime between now and Christmas. So that's especially the proportionality is for me a concern. When it comes to independent oversight, I think there is sufficient internal independent oversight with the Inspector General and the Civil Liberties Protection Officer and senior level compliance officers that need to be in place. I think that's a good step in the right direction. Whether or not the oversight by the court is effective enough is something that also remains to be seen. I think also there we probably will have to wait for any joint review that will be agreed between the European Union and the US on this mechanism, and also the oversight by PCLOP again, to see if it is actually an independent enough. I'm hopeful for this court. I know that a lot of people in Europe say, well, this is not part of the judiciary, so how can it be a court and how can it be judicial redress? And there,
we got all kinds of judges.
Yeah, and there I think the US legal system is really different. If I read the analysis of Ken Propp, Peter Swire, and Theodore Christakis that was released yesterday on Wednesday by the IAPP, I think they make a good case on why this is and should be seen as an independent court in the meaning also of what Europeans believe to be a court. And just looking more broadly at the redress mechanisms, yes, in Schrems II, the court criticized that there was no judicial redress, but more in general, the courts have said for government surveillance that also administrative redress would be an option if that is sufficiently effective and independent.
Right.
I think this qualifies, at least in my perspective, more as administrative redress than as judicial redress.
Probably
but that's with my European lens on.
Because there will be regulations issued under it. So a lot of the regulations establish the administrative courts because it's administrative law, because it's regulations. And so it'll probably be that. However, our administrative courts are answerable to the United States Supreme Court.
Okay, but it's not clear yet whether that is also the case for the Data Protection Review Court.
It probably will be. I can't imagine us stepping outside something so well entrenched in our law to do something different for something that would hurt us if they did it that way.
Yeah, so I mean, for the court, I'm willing to give it the benefit of the doubt for the time being. Does that mean I'm convinced that the adequacy decision will go through? No, and that is mainly because of the proportionality issue. There, I really think that is an issue. And should this fail before the Court of Justice, then also likely it would be on the proportionality issue.
Yeah.
Other concern, obviously, is that we cannot use it yet. I had hoped really that from the moment that we saw the executive order, that at least it could be used in conjunction with the standard contractual clauses as part of the supplementary safeguards. We cannot because it's not fully operational yet. We have to wait for the additional guidelines and implementing regulation that will come in the next 60 days. And then indeed, as you just raised, we have to wait for the designation as a qualifying state.
Right.
So this is probably a way of saying, okay, we need some form of reciprocity.
Yep. Sounds a little like China, but
Well, I mean, it's not unfair to request reciprocity on an issue like this, but this is probably the most vague provision in the whole executive order, because also here it is not spelled out that there will be additional guidelines or regulations or public assessment criteria. When a country wants to become adequate, they can just look up the referential from the European Union and from the European Data Protection Board on what they will be assessed against. And that is completely unclear right now when and how the US will come to the conclusion what counts as a qualifying state.
Right.
And how will they do this for the European Union? Because the European Union in itself has no competency for government surveillance. All the individual member states do, but are they really going to assess all the individual member states between now and the end of the year?
I got a question for you. Do you think that was a provision worked out between the European Commission and the U.S. to ask for this type of reciprocity? That way the European Commission might have a larger insight into what the individual countries are doing?
I'm sure it came up during the negotiations. I mean, this is not something that the U.S. would have sprung on the European Union in the final version of the executive order. I'm pretty sure that this was already there. It was also briefed before the publication of the executive order because Politico already started talking about it hours before the order was actually released. So this was known on the European end. But I'm really hoping that this will not be a way for the US to say, okay, well, the Netherlands, Denmark, and Sweden will get qualifying state status, but Germany and France not.
Yeah, peace and parts. Yeah,
that would really be unacceptable from a European perspective.
I don't think they do that. Now, of course, I'm pretty naive when it comes to political machinations, apparently, but I would like to think they're not. That's not the intent. I think the intent is maybe to start establishing a baseline.
Well, let's hope so. And this, of course, I mean, this provision also makes it more easy for Switzerland to join, for the United Kingdom to join, and maybe also for other jurisdictions around the world, for Brazil or South Africa, or maybe even China. Unlikely, but...
Hey, I hear they got a pretty strong privacy law.
They do, but maybe that's not what is called in the best interest of the United States.
Probably not. But they did give some examples. I forget whose analysis I saw it in, but examples of where certain companies or certain interests might outweigh other. I'm not saying this correctly. I should pull up the analysis and read it. But along the lines of if there is a bank in the Netherlands that is co-owned by someone in Russia or someone in China, then it would come under greater scrutiny than others. So there are still major government targets or people within their, line of sight that they are more interested in that might call for some exceptions to the process, depending on what it is. But the exception wouldn't be based on, well, there's a bank in the Netherlands co-owned by someone in Spain. It would be some of the larger targets that the U.S. intelligence agencies have on their radar, which makes sense.
I think it does. So what is your overall gut feeling when you've read the executive order and accompanying documents so far?
My first thought was, well, dadgum, it's about time this came out, right? Second was, I think they actually put a lot of work into it. As you said, given all the things that happened at the same time, even though they weren't issued in one big, nice pack, all the things that were happening at the same time that came out, which, like I said, I overlooked the statement from the Department of Commerce. So I think that is a positive sign that they've got a lot of the pieces moving at the same time. And I think that gives some idea to Europe and maybe the rest of the world of how very complex the U.S. is in the different agencies and the powers to be able to coordinate this type of a massive action. So I was thankful they finally did. I was pleasantly surprised at the amount of work that looked like it had gone in place already. But I was disappointed I didn't feel it went far enough. I think the executive order in and of itself is fine. And I do think that, as I've stated before, even if it's not fine, I think it's going to be a starting point for Congress to actually pass some law. I think that's going to be good. Y'all have heard my opinions on that before about Congress and privacy laws. So, and I don't know where I can tell you that I don't think it went far enough.
Okay.
But
that's also part of your gut feeling.
Yeah, something tells me there's a little something missing here. And I'm not quite sure what that something is. I think it went as far as it probably could go for what it is. And maybe the details or what I'm looking for are going to be in these regulations that are going to come out.
I hope so.
That might be.
I share that feeling.
Waiting on that other shoe to drop, right?
As I also wrote on Twitter, I was more hopeful before the release than after the release that it would be good enough.
Well, I think it's interesting. First of all, clearly, whoever's job it was to take Max Schrems out and get him drunk failed. Clearly they failed, or else he's reacting from a hangover. I'm not sure what. But, if Schrems caved, and apparently he's the honorary chairman of NOYB. I saw that too. He's the honorary chairman. But if he caved,
it only means that he doesn't get paid. He still puts the same amount of work in.
Yeah, probably a lot more work for that matter. But if he caved too easily, I think people would be wondering what's going on. Wondering if he got paid off, if he got bribed, something like that, if he caved too easily. So in some ways, I think this is, you see the plot line in books sometimes that I'm thinking of the David Eddings and the Belgariad, if anyone cares, where the kings are all arguing against Sinedra, and the one that's always the biggest and the brashest and the most argumentative is taking her on, and everybody's behind him. And then when he goes, okay, I can agree with that, nobody else has a leg to stand on because he wiped it all out. So hopefully that's kind of where Max Schrems is going to fall, is that people are going to back him for questioning it. And then once he is satisfied, there really shouldn't be any other objections. He will probably cover them all.
Yeah, well, there, I'm not so sure what will happen, to be honest. What do you think of the view of Cameron Carey of the Brookings Institute, who said this is a good start, but maybe at some point, some elements of this should be codified by Congress?
Oh, I absolutely agree with that. I think that was the first review that I read because I was looking for that one. So yeah, I agree with him. I believe that for longevity, and I think that's what the purpose of this is to get Congress to codify it. If they don't codify it, it still has the force of law. And if they don't pass another law that preempts it, pass a law that preempts it or gets rid of it, then it's still there. But I believe I think it's the starting gun. I believe the shot has been fired. And now we're waiting on them to codify something else, codify this, something. But unless they do pass something, this has the force of law, period.
Yeah, I think that's undisputed, at least undisputed by me. I'm still struggling.
You are all that matters.
No, I'm not. I'm still struggling to see how this will impact my transfer risk assessments for the US until there is an adequacy decision, which won't come until spring. So there is still a long way to go.
Yeah, that's one thing people need to know. This doesn't mean in 60 days we're going to have regulations, we're going to have proclamations, we're going to have a EDPB opinion, we're going to have an EC final. No, none of that's going to happen for, probably not even going to have an EDPB opinion for 6 months, 4 months?
No, I think the EDPB opinion probably by February. It also depends on when the Commission will release all the adequacy documents, because, of course, the adequacy decision will need to include all the former Privacy Shield principles. Now, the framework principle, that is still coming, and that needs to be part of the assessment. Obviously, this is a big part of the whole assessment.
Okay, question then. So we know this is going to take a long time, at least 6 months. The end of this year are when the new standard contractual clauses are supposed to all be in place.
Yes, 27 December.
Exactly. So you're supposed to have the new standard contractual clauses in place. I've been known to say before that I'm not sure that companies that have put standard contractual clauses in place with their vendors in the U.S. are going to be willing to back off of those standard contractual clauses and rely on the new thingy whenever the new thingy is in place. So they've negotiated them. They've gone back and forth. Well, not the standard contractual clauses per se, but the DPAs that go with the standard contractual clauses. What are the U.S. companies supposed to do that join that, one, are still part of the SHIELD framework because it's still a government enforced, even though Ralph laughs at me. I cannot let you and Ralph decimate the U.S. privacy shield while I'm gone for 2 weeks. So, but for the companies that stayed a part of it, that are relying on the new one, which they said they will transition, which is the same thing we've said all along. Once there's a new thingy in place, there will be a transition plan for those that are still part of the shield. But, we had over 5,000 companies that were part of the shield before. I think there's 3,000 or so left. But what do? The companies they've negotiated DPAs with aren't going to want to back off the DPAs. It's not the DPAs. It's the standard contractual clauses. Are we just going to wholesale get rid of them if they're in place, if companies sign up to the new thingy? I don't know. I don't know what those contractual negotiations are going to look like.
Legally speaking, as soon as there is an adequacy decision, the standard contractual clauses become null and void.
That's right. They're invalid. Thank you. Clearly, I needed more coffee. That's right.
But that is only if the counterpart has self-certified under the EU-US data protection framework.
Okay, so y'all people are listening to this, right? If you're still part of the SHIELD, there's going to be a transition plan. Once there's an adequacy decision, and the adequacy decision will not be to the U.S., it will still be to the construct. So, yeah, okay.
So once there is an adequacy decision and the company self-certifies under the new framework, then automatically the standard contractual clauses become null and void. If you have signed them, I would say keep them in place because they will magically reactivate if the adequacy decision disappeared.
Magically? Delicious. So yeah, that is true. Okay, so I like that. I still believe in the thingy. The thingy is going to happen. It's still going to be good. We'll have an adequacy decision there. And if Congress gets off their butt and actually passes a federal privacy law, because if y'all haven't heard it before, you might as well hear it now. No U.S. state is going to be granted adequacy for the state omnibus privacy laws. It's not going to happen. Don't even think about it. It can't happen legitimately. So the U.S. Congress do what?
Under U.S. law, it cannot happen.
Right. So under the Congress, U.S. Congress has to pass a federal privacy law that is sufficient under EU law to grant similar protection, essentially similar. So it has to go beyond similar, essentially similar protections to those who are subject to the GDPR. And if you notice, I don't say European residents or citizens. It's whoever is subject.
Nationality doesn't matter. It is about fundamental rights and they apply to everybody.
Yeah. So they need to grant essentially the same protections as people have under the GDPR. So,
well, that's the good thing about the executive order, and that really surprised me, that U.S. persons and non-U.S. persons are to be treated exactly equal.
Yeah.
When it comes to the use of their data, when it comes to the retention of their data. And
have you missed that point?
Forward.
Our intelligence doesn't give a crap about us as citizens either.
No, but your legislation so far seemed to make that distinction.
Just saying, they're going to collect data and then not tell us about that too. So. Oh, but no, seriously, I think that is good. When I saw that, I was very pleased on your behalf because I know that that's something you care. Well, I mean, it's something to care a lot about. It should be equal. But yeah, so I'm hopeful that this is going to work. I'm eager to see the regulations that are going to come out. I'm eager to see what the principles are going to be. I'm eager to see what the process for submitting complaints is going to be. I want to see more.
Can we say that the glass is at least half full?
I think the glass is at least half full.
Oh,
at least.
If you were looking for the endorsement from Serious Privacy, you don't have it yet. But
it's trickling in. It's like a pipe that is mainly clogged. It's trickling in, but if you leave it there long enough, it will continue to fill.
Hopefully. So on that note, we'll wrap up another episode of Serious Privacy. If you like this conversation, please share it with your friends and family and your colleagues and everybody around the world who has an interest in privacy and data protection and government surveillance. If you want to join the conversation, tag us on LinkedIn. You'll find us under Serious Privacy. Find us on Twitter at Podcast Privacy. You will find Kay on Twitter as Heart of Privacy and myself as Europol B. Thank you for listening. Until next week, goodbye.
Bye, y'all.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.